So, welcome once again to Ethics for Transactional Attorneys. Let's start here. And first, I'm going to show you the legal notice that states basically any opinions that are provided by the presenters, myself and my colleagues, may not reflect those of Lexis, as well as about our copyright and trademark issues. So I want to make sure I cover that off. Moving on. So this CLE will cover a range of topics and ethical dilemmas that are encountered by transactional attorneys. Those are, after the introduction, the sources of ethical principles we'll be covering, the lawyer's role in a transactional space, adversity and conflict, and then we'll be covering social media and electronic communications. I hope everybody can hear me clearly on my headset, as well as I'm hoping WebEx keeps up to the presentation. So I will try to delay a bit when possible, just in case there is a lag in WebEx and the information not presenting itself on the screen. So to start, first off, I'd like to acknowledge a couple outside experts that contributed to the content of this CLE webinar. They are not in attendance today, but Stephen Tepper and Susan Shin, both from Arnold & Porter, their contributions were critical to this presentation. As for the presenters, there will be two of us today. Myself, Marty Judge. I am the Lexis Practice Advisor Specialist at LexisNexis, and that covers not only Lexis Practice Advisor, the solution that we have developed specifically for transactional attorneys, but Knowledge Mosaic. And I am a licensed attorney in the lovely Commonwealth of Massachusetts. Also joining me today is a colleague, Robin Schneider. Robin is the Manager of Content and Product Initiatives for Lexis Practice Advisor, and she will be sharing some of her experiences as we go through this content based on her 13+ years of legal experience. And Robin, I'm hoping that you will have audio when the time comes as well, if you do not have it already.
I think I'm here.
Oh, perfect. Great. Thank you. So let's get started. Let's talk about, first off, the sources for ethical principles. The ethical rules are governed by the American Bar Association. They were adopted in 1983, and they serve as the basis for, or have been substantially adopted by 49 states. Now, I would like to note that these are minimum standards that lawyers should follow. So I want to emphasize that these are the minimum standards that lawyers should follow. So first off, we're going to talk about the roles of a transactional lawyer and some of the varied hats that transactional attorneys wear. And those are a lawyer as a legal advisor, lawyers as negotiators and business advisors, lawyers as investigators, and lawyers as gatekeepers and trusted advisors. So we're going to start with lawyers as legal advisors. And the ABA Model Rule 1.6a defines confidentiality of information as a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. And paragraph B itemizes certain circumstances in which a lawyer may reveal information relating to the representation of a client under certain circumstances, and we will cover some of those later in the presentation. So, question, how does the ABA Model Rule of confidentiality of information differ from the attorney-client privilege? Well, confidentiality is an ethical rule, while the privilege is an evidentiary rule. The attorney-client privilege applies in judicial proceedings, while confidentiality applies to all information relating to the representation of a client. The attorney-client privilege is much more specific. And I'm seeing some notes here that Meredith, I'm hoping you can see too, that Nancy says that she did not receive the email for the CLE and gives her email address. So I'm hoping that you can see that as well. If not, Nancy, we will make sure that we get those to you. Thank you for the note. Moving on. One of the most important duties of a lawyer is to preserve his or her client privilege communication. So the attorney-client privilege protects a communication, made between clients or their agents and their attorneys or their agents in confidence for the purpose of obtaining or providing legal assistance for the client. All right? So, are there standards for determining who within an organization participates in an attorney-client communication? Yes, there are two tests. The first is the control test, which is a bit more stringent, and it says a corporation can claim the attorney-client privilege only as to statements made by employees in a position to control or even to take a substantial part in a decision about any action which the corporation may take upon the advice of an attorney. There's a less stringent test, and one that is followed by a majority of federal courts, called the subject matter test, and that focuses on the relation of the subject matter of the communication at issue to the responsibilities of the employee toward the company. So there are two tests. One's more liberal, and one is followed by a majority of the federal courts, but still there are two tests. So, fundamental question, who is the client? So not all corporate employees can be deemed a quote-unquote client for attorney-client privilege purposes. In the corporate context, the client is the corporation itself, not its employees. And so there is also communication with non-attorneys that may happen when it comes to the attorney-client privilege. And the privilege also may apply to non-lawyers hired by lawyers when the communications are made in confidence at the instruction of attorney and for the purpose of rendering legal advice.
Hi, Marty.
Yeah, you were going to talk in
there. I have
there.
A question for you. So would
Okay.
financial advisors be covered by the privilege?
Well, are they hired by the attorney?
Yes.
Okay. Were they acting under the instruction of the attorney?
Yes.
I'm going to say yes, they would be.
And what happens if the financial advisors are meeting with the client but the attorneys are not present? Would that change the answer?
I'm hoping you have the answer because I don't.
I actually don't think it changes the answer.
Okay, thank you then. All right. So let's go on to the scenario where the lawyer is acting as a negotiator or business advisor. Another situation that transactional attorneys find themselves in. So first off, when speaking to third parties, Model Rule 4.1a, a lawyer may not lie to third parties. Well, actually, the model rule reads, lawyers shall not make false statements of material fact or law to third persons, but we kind of boiled it down to its essence. I hope you don't mind we took the license on that one. So what is the attorney's obligation to third parties? Well, they shall not lie to third parties. Model Rule 8.4c, lawyers may not engage in dishonesty, fraud, deceit, or misrepresentation. Sounds logical enough. There is an ABA opinion that deals with puffing. Now, this is where things get a little bit gray. So when puffing, what is normal, maybe negotiated language, expected lies versus misrepresentation of material fact? Where does the line between those lie? I think you would say that a situation where a lawyer says, my client will never accept a certain price for something can be puffing, normal negotiated language. But if they make a statement about the property has been tested for asbestos and there is no asbestos there, and that's known not to be the fact, then that could be a misrepresentation of a material fact. So there's a circumstance where that gray area might be quite well defined in between negotiating language and between a misrepresentation of material fact.
Marty, I'm going to share a real-life example here. I was working on a matter once, and the clients wanted the law firm, our law firm, to issue a press release making a statement that the other side was not negotiating with us, and that frankly just wasn't true. They were negotiating. We just weren't getting the outcome we expected or desired, and we made the decision as lawyers that we could not issue the press release. And it made for a little bit of an unhappy client at the time, but really we had an ethical obligation not to issue that press release.
Ah, okay. I just want to do a little informational note here. Some people have emailed that they did not receive the CLE certificate, and we've asked them at the beginning to to use chat in order to notify us if they had not received it and provide or confirm their email address. And I know a bunch of people joined after the start of this, Celie, so please, if you had not received the email certificates, please let us know on the chat button and confirm your email address. Thank you.
Yes, and Marty, this is Meredith. I'm actually I'm trying to send those out as I'm getting the chats. It's just, I'd say there's going to be a couple seconds of lag time as I try to get to those chats and set up the emails, but I'm sending those out.
Perfect. And for those of you also that joined late, there is the need to have a 4-digit code to put on those evaluations, and the 4-digit code at the start of the CLE is 0505. There'll be a second code at the conclusion, but I just want to make sure that those of you that joined a bit late had the starting code for the webinar, and that is 0505. So continuing on, lawyers as business advisors. For the attorney-client privilege to attach, the attorney must be acting the role of a lawyer. Now, courts are very wary of lawyers acting as business advisors, negotiators, investigators when trying to apply the attorney-client privilege, because the privilege doesn't apply when the attorney is wearing just a business-related hat. So the question is, when is a lawyer not a lawyer for purposes of the privilege? And the courts have distinguished these two functions and have provided some inquiries to assist in defining when a lawyer is in a legal role or a pure business role. And those inquiries are, could a non-lawyer perform a given task? For what purpose was the lawyer contacted? And did either the client or lawyer give any indication regarding their understanding of the nature of the lawyer's role? Question mark. Note, attorneys with multiple functions won't necessarily be precluded from the application of the privilege, but you should be careful as to if you're offering just business advisor role versus an attorney's role and trying to attach the attorney-client privilege to that role. So, lawyer as a negotiator. Here we'll start off with the non-contact role in negotiation and when speaking to third parties. So the ABA Model Rule 4.2. In representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or by court order. And there's a comment to that rule, comment 7, which describes employees who are out of bounds to the opposing lawyer as a constituent of the organization who supervises, directs, or regularly consults with the organization's lawyers concerning the matter, or has authority to obligate the organization with respect to the matter, or whose act or omission in connection with the matter may be imputed to the organization for purposes of civil or criminal liability. And the reasoning behind the model rule is stated to foreclose communication between an opposing lawyer and what may be a relatively unsophisticated employee of the company. So that's the basis of the no contact model rule 4.2. So now we're going to move to lawyers as investigators, another hat that transaction attorneys wear from time to time. And we're going to start with internal investigation. The issue that comes up most often with internal investigations is defining the scope of the work product privilege, which protects materials produced in the course of an internal investigation and created in anticipation of litigation. And that's a critical aspect of it, anticipation of litigation. Specifically, the critical issues that the court have addressed in context of internal investigations include whether the investigation was undertaken in anticipation of litigation, whether materials are fact or opinion work products, the extent in which the attorney's conducted the investigation, and the extent to which disclosure to a third party waives work product privileges as to all investigatory materials. So once again, lawyers as investigators, in internal investigation, these are some of the items that you should be aware of to protect the work client privilege. So, question. A lawyer should have answered or be aware of who, first off, is the client. So common candidates are the corporation, the board, audit committee, or other special committees of the board. What role is the attorney playing in the investigation? Is it a factual or a legal investigation? What is the end product of the investigator? Is some report going to be published? What is the substantive law giving rise to the legal duty to investigate, if any? Is the lawyer investigator also giving behind-the-scenes legal advice on the matter? So those are some of the matters that you should look at. Continuing on with lawyers as investigators, the attorney-client privilege for internal investigation. Here we're going to cover the Upjohn warning. So Upjohn versus the United States in 1981, an attorney-client privilege attaches to communications by employees made to attorneys in order to provide legal advice to the corporation. Upjohn warnings inform employees that conversation is privileged, but the privilege belongs to the corporation, not the employee. This warning is required and must be robust, and there should be no confusion or misapprehension on the part of the employee that the lawyer represents his interests should those interests diverge from that of the corporation. And the components of an Upjohn warning are the attorney represents the corporation, not the employee. There is no attorney-client relationship between the attorney and the employee. The attorney is acting on behalf of the corporation and gathering information to provide legal advice to the corporation. The interview is confidential, and the employee should not disclose communication to avoid waiving the privilege. The privilege belongs only to the corporation, not the employee, and thus the corporation and the corporation alone can decide to disclose. And lastly, the attorney must give the employee opportunity to ask questions. So those are the important elements or components of the Upjohn warning as they pertain to attorney-client privileges for internal investigation. Let's move on to the work product privilege. What is protected by the work product privilege? Note, the document must be prepared in anticipation of litigation and at the direction of counsel to be protected. Now, there's also a note here that attorneys should be careful with the attorney work product legend on documents, as they can trigger a duty to preserve documents. If a potential litigant is deemed to have been on notice of pending or future litigation, a duty to preserve relevant evidence and documents is triggered, which includes 1, suspending routine document retention and destruction policies, 2, sending out litigation document hold notices to key players, and 3, monitoring compliance of that litigation hold. And Robin, were you going to give some experiences in this realm?
Sure. So when I was practicing in a law firm, I know just in our practice every day, we would typically write attorney work products on almost every document that we worked on, whether or not it was going out to a client. Later in my career, I transitioned and I was an in-house attorney, and basically no one used the attorney work product legend on documents. And the idea behind that, and there was great discussion about this, is that when you're working in-house, when you're sending documents in-house to other lawyers or to the business side, everybody's the client, and therefore you don't need the legend. So just an interesting differential between in-house and law firm life.
Thank you, Robin. We're now going to move into the section of lawyers as gatekeepers and trusted advisors. And we're going to start off with duties to third parties and the model rule 2.1. And it reads, in rendering advice, a lawyer may refer not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Comment 2 of Rule 2.1 reads, although a lawyer is not a moral advisor as such, moral and ethical questions impinge upon most legal questions. Rule 1.2 goes on to say, A lawyer shall abide by the client's decision concerning the objectives of the representation and consult with the client as to the means by which they are to be pursued. A lawyer's representation of the client does not constitute an endorsement of the client's political, economic, social, or moral views or activities. And we have an example here of maybe something that would fall into that realm. So one of your clients has found a legal way to raise the employee's pension fund for purposes of paying executive bonus. Although legally permitted, your role is to advise as to the moral and economic consequences of that action. The rule makes it clear, however, that the ultimate responsibility in that circumstance lies on the client, not on the attorney. So, moving on. Client fraud in the organizational context. Rule 1.13 reiterates that lawyer is employed or retained by the organization, either inside or outside, and represents the organization. If the lawyer for the organization knows that an officer, employee, or other person has or intends to violate a legal obligation to the organization or a violation of the law that might be imputed to the organization, and that is likely to result in substantial injury to the organization, then the lawyer shall proceed as reasonably necessary in the best interest of the organization. And that means going up the ladder, so to speak. This means reporting to the higher authority in the organization and, if necessary, to the highest authority. There's a note here. If the highest authority fails to act where there is clearly a violation of law, and the violation is reasonably certain to result in substantial injury to the organization, then the lawyer may reveal confidential information, notwithstanding Rule 1.6, which is the confidentiality rule that we talked about at the outset, to the extent that the lawyer reasonably believes necessary to prevent substantial injury to the organization. So this is one of these 1.6b circumstances. There's a note here, too, that in New York, you can, oh, hold on, I will hold that one for a moment here. I got a little bit ahead of myself. Rules different with regard to client fraud. So Rule 1.2d, lawyer may not counsel a client to engage or assist a client in the conduct that the lawyer knows is criminal or fraudulent. Rule 4.1, lawyer shall not knowingly fail to disclose material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited by 1.6. 1.6, lawyer may reveal information to the extent that the lawyer believes reasonably necessary to prevent certain death or substantial harm, prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another, and in furtherance of which the client has used or is using the lawyer's services, to prevent, mitigate, or rectify substantial injury, etc. So here's the note for those of you that practice in New York. You can only breach confidentiality under 1.6 of the model rule to prevent death or substantial bodily harm. So there's a note for you New York practitioners. Lawyer as gatekeeper. Now we're going to talk about, for those of you who do SEC reporting requirements. So the SEC has its own rules with regard to reporting. And the rules originally proposed by the SEC would have required what they call a noisy withdrawal. But the bar was able to get those rules and said that they would create a big hole in the attorney-client privilege. So the SEC modified and proposed the rules today, which are more similar to the model rules from the ADA, which require reporting up the ladder within the organization. But one of the critical tests is when you talk about what is appearing and practicing before the SEC, and they say that they shall report evidence of material violation to the issuer's chief legal officer or to both the issuer's chief legal officer or its chief executive officer. And so what does it mean to be appearing or practicing before the SEC? The regulations mandated by the Sarbanes-Oxley Act in 2002 states that for purposes of appearing or practicing before the SEC, it's lawyers who prepare SEC filings, lawyers who review portions of SEC filings, lawyers who prepare a contract that he or she knows will be filed as an exhibit to an SEC filing. Not aware of that one, by the way. Supervisory attorney of a subordinate attorney who is appearing and practicing before the SEC, and the chief legal counsel, even if the SEC duties of the chief legal counsel have been delegated. So those are SEC reporting requirements for those that practice in the SEC bar. So moving on to supervisory lawyers, we will talk about Rule 5.1. Partners and others with managerial authority in the firm must make reasonable efforts to ensure that the firm has taken measures to give reasonable assurances that all lawyers in the firm conform to the rules. Rule 8.4a, it is professional misconduct for a lawyer to knowingly assist or induce another to violate or attempt to violate the rules. It says there's a note. Other than these two rules, a lawyer does not have a disciplinary liability for the conduct of a partner, associate, or subordinate. Now remember, once again, these are minimum rules set up by the ABA. So moving on to subordinate lawyers, Rule 5.2a. A lawyer is bound by the rules, notwithstanding the lawyer acted on the direction of another person. And subsection B, the subordinate lawyer does not violate the rule if he/she acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. And this hinges on the reasonable resolution statement here. So what is reasonable resolution? Hypothetical. A junior lawyer goes to a partner and says, don't we have a problem? Aren't we representing the other side in another case? And the partner says, no problem, we're okay. Under that situation, the junior lawyer may still have an obligation to report the violation because that's not really a reasonable resolution to the conflict, that being the partner saying, no, we don't have a problem, we're okay. Most firms give a lot of avenues for young attorneys to report conflict they come across, including ethics committees, mentors, and hotlines, et cetera. And so they should avail themselves of that, those resources in order to protect themselves from some violation under the rules. So now we're going to talk about adversity in the transactional context and conflict. So conflicts involving multiple clients, 1.7a. A lawyer shall not represent a client if the representation involves a concurrent client conflict. Oops, I did not mean to do that so far. Sorry, going to go back here. So comment to 1.7 says, a lawyer who represents an organization does not necessarily represent a constituent such as a parent or subsidiary. You can accept representation adverse to the affiliate of your client unless the matters are related, the circumstances are such that the affiliate should also be considered a client. There's an understanding with the client that you won't be adverse to an affiliate, or your obligation to the organization client and to the new client are likely to materially limit your representation of either client. So those are some notes that are in 1.7 or a comment regarding conflict. Now we're going to cover a type of conflict known as a thrust-upon conflict, which is a conflict that arises through no fault of the lawyer and in a circumstance where a client refuses to consent to simultaneous representation. So here's an example on your screen. A thrust-upon client conflict, you represent client A in the upper left-hand corner circle, and you represent client B in a joint venture with client C, which is represented in the bottom circle. During the course of the representation, client A acquires client C, so the question is, what do? There's a thrust-upon conflict. So, a conflict that arises through no fault of the attorney, Model Rule 1.7 Comment 5 states, depending on the circumstance, the lawyer may have the option to withdraw from one of the representations in order to avoid the conflict. The District of Columbia Rule 1.7d states a little bit differently that if the conflict is not reasonably foreseeable at the outset of the representation and is not waived, the lawyer need not withdraw from any specified circumstances. I'm sure that's going to stop repeat business, but I guess that's what the rule says in D.C. So moving on to adversity in the transactional context and conflict. Model Rule 1.9a, duties to former clients. So a lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent confirmed in writing. There was a case in the matter in 2012 dealing with the law firm Latham. It was Eon versus Flow TV, and the Latham was disqualified in a patent case even though 17 years had elapsed since the firm represented the client. The issue really turned on the confidential information. If information about the client obtained in the prior representation, no matter how long ago or how unrelated to the current matter, might be relevant to the new client, matters could be found to be substantially related. And in that case, they had a conflict that they had to resolve. So, conflict, what's the best way to navigate around these types of conflicts? Simply an engagement letter. They should spell out the possible conflicts that may arise and what to do if those do arise. Clients should also be reminded that clients have the right to seek independent legal advice and should make it clear that you can share confidential information with other members of the group and or representation. With respect to former clients, there should be a clear end to the representation. One option is to send a closeout letter. I know we all don't like to send closeout letters on clients. They want to be clients for life, but to avoid conflict, that's one way to resolve the matter proactively. So, adversity and transactional context conflict continues. ABA Opinion 95-390. The circumstance of a particular representation may be such that corporate client has a reasonable expectation that its affiliates will be treated as clients themselves. There's a New York City Bar opinion that lists factors that would lead to a conclusion that the affiliate is the de facto client. The best solution is to make sure that there's a clear understanding between the lawyer and the client as to who the client is and that the engagement letter reflects it. And there's a case on point here, GSI Commerce versus Baby Center of 2009, where the engagement letter stated that the firm represented only Johnson & Johnson and not its affiliate. Blank & Rome was disqualified from representing another party in the case that was adverse to Johnson & Johnson affiliate. The court looked at the operational commonality. Since the parent and affiliate had shared audit departments, IT departments, and most importantly, a common legal department, they were deemed to be the same entity, regardless of the representation letter. So now we're going to move on to social media and electronic communications, and the ABA has made some language adjustments to reflect the change in technology around a couple elements of its model rules, one of them being technology and confidentiality, and the second, technology and client development. So, changes to Rule 1.5c. These are language changes that have been made recently. In Rule 1.18, duties to prospective clients, the word discusses was replaced by consults with regard to potential client-lawyer relationships, and had discussions, quote unquote, was replaced by learned information from. So consults will play a big role in the changes. In the comment to Rule 1.18, language was added to clarify how a person becomes a prospective client and states that a consultation hinges on whether the lawyer specifically requests or invites the submission of information about a potential representation without clear and reasonably understandable warning and cautionary statements that limit the lawyer's obligation, and a person provides information in response. In contrast, a consultation does not occur if the person provides information to a lawyer in response to advertising that merely describes the lawyer's education, experience, area of practice, and contact information, or provides legal information of general interest. Additional language, interview, quote unquote, and conversations, quote unquote, were replaced by consultations as well. In the comment to Rule 7.2, advertising, the rule on lawyer advertising clarified when a lawyer can pay another to generate client leads, such as internet-based client leads. Quote, as long as the lead generator does not recommend the lawyer, unquote. In a comment to Rule 7.3, solicitations of clients was addressed and clarified. Modified language stated that a solicitation is a targeted communication initiated by the lawyer that is directed to a specific person and that offers to provide or can reasonably understood as offering to provide legal services. In contrast, a lawyer communication typically does not constitute a solicitation if it is directed to the general public, such as through a billboard, an internet banner advertisement, or website or television portion, or if it is in response to a request for information or is automatically generated in response to internet searches. So, moving on to social media and electronic communications. Technology and confidentiality. The changes to 105A. A writing or something written now includes electronic communications, which replaced email. And so obviously with chat and text and everything else, email is not the only mode of electronic communication. In the comments to Rule 1.1, competent, which states that lawyers shall provide competent representation to the client, the delegates added that lawyers, quote, should keep abreast of changes in the law and its practice, unquote, including the benefits and risks associated with relevant technology. In the comment to Rule 1.4 communication, the language, client telephone calls should be promptly returned or acknowledged, was deleted, and the delegates replaced the language with a lawyer should promptly respond to or acknowledge client communications. In the comments to Rule 1.6, confidentiality of information, the delegates added the language, a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information related to the representation of a client. So here's the whole IT security section. In the comment to 1.6, acting competently to preserve confidentiality, the delegates changed the language and added language addressing disclosure of and access to information. In the comment to Rule 4.4, respect to rights of third parties, third parties, which states that lawyers who receive a document, the language or electronically stored information was added. And Robin, were you going to share an experience around social media and electronic communications with the group today?
Sure. So just an interesting, funny story to end our discussion on inadvertent disclosure. I was working on a bankruptcy matter. This is years ago when really we first started using email. So I'm showing my age here a little bit. And it was a contested matter, and we were due to be in court the next morning at around 9:30. And at about 8 o'clock at night, I received an email from a partner who was the opposing counsel, and it said, Dear X, here are my thoughts on our witness list for tomorrow. It's complete. Please don't send it over until 11:59 p.m. tonight because I want to screw with the lawyer on the other side. So I obviously received that email in error, and I showed it to the partner I was working for, who promptly wrote back to the opposing counsel and said, hey, thank you, this was an inadvertent disclosure of your witness list, and I appreciate your comments on me and our team here. And of course, we got an email back immediately from that other partner, opposing counsel, basically saying that was an inadvertent email disclosure, please disregard, please delete, please put in your permanent trash folder. Well, lo and behold, about 4 or 5 years later, I had completely forgotten about the situation, and I lateraled to that firm that was opposing counsel. And on my first day, I was talking to, and I was introduced to a partner, and he said, hey, I worked with your old firm on this matter, X. And all of a sudden, it dawned on me that that was the partner that had sent me the inadvertent disclosure email. So these things have a funny way of coming back, and they really do happen in real life. So inadvertent disclosure is something people really need to pay attention to in this email age.
All right. And that is the conclusion of the ethics for transactional attorney